Hi, everybody. I'm Michelle Morris from Consolidated Planning Group. Thank you for coming to our webinar today. We've got a great topic. It is so important. And this is such a popular topic. Everyone has questions about wills, trusts, and guardianships. And these are so hugely important when you're planning to take care of someone for the rest of their lives. And more importantly than that, even after you're gone, they're going to need your care and your support. So, how do you set these things up while you're still here alive to make sure that your loved ones are going to be taken care of once you're gone? That's really what we're going to be focusing on today with attorney Rachel Dickison. Thank you, Rachel, for being here with us. We're also being partly helped out by Nicole Crowder at Conroe ISD. She's part of the Parent Resource Center there in Conroe. Is that right, Nicole? Thank you for being here with us today. Um, and I really, really want to take a minute to focus on thanking all of the attendants because I'm starting to feel like we're building our own little army of advocates here. I mean, there are so many people in the special needs community who need help, who need answers. And I feel like by educating the community, we are really helping to create a community that understands and can give thoughtful, helpful answers instead of just, whatever. And people who understand, what needs to be done and that not the answer is not the same for everybody. I've heard so many stories, and I know I'm getting off track a little bit here. I promise I'll get back. I've heard so many stories of helpful friends and neighbors who, they say things like, oh, well, your child has the same diagnosis as mine, so you should be on this and do this and get these benefits. Well, if that person doesn't know all the nuances of your situation or all the eligibility criteria for these different programs, they might be giving you completely inaccurate advice, even though they're trying to be helpful. So, by coming to webinars like this and learning for yourself, that is so empowering to you as parents. And even people who think, oh, we're so far behind in planning or we haven't done anything yet. I just want to commend you on taking the step of being here and watching these webinars and trying to educate yourself because that is so, so important. So, we at Consolidated Planning Group, we are financial advisors who focus on serving the special needs community. We full-time financial advisors, but also full-time special needs planning experts and consultants. We do this for families all across the United States, even though we're located just outside of Houston, Texas. We can serve families anywhere. So please spread the word about us, share these webinars, share our contact information. We can help anywhere in the United States. We've been doing this for over 30 years. We are fully licensed in things like life insurance, investments, securities, anything that any traditional financial advisor would do, we can do for you. But we do it through that lens of understanding that your child might need your help for the rest of their lives. Not only are we fully certified and licensed in financial advising, we are also special needs members of the Special Needs Planning Academy. We are chartered special needs consultants, and we are nationally certified Social Security advisors. We have furthered our education in the special needs planning arena so that we truly understand those nuances and criteria and eligibility and what programs are available for people out there. But I think our most important, um, the most important reason that you should work with us at Consolidated Planning Group is because all of the financial advisors here are also parents to loved ones with needs. We live this with our own families. We work this. We every single day and night. We eat, sleep, and breathe, helping families like yours. So this is a very, very serious topic for us. And people come to us for things like lifetime care and protection plans, transition planning and ABLE accounts, understanding things like that future cost of care. How much money is your loved one going to need even after you're not here to take care of them? What those state and federal benefits and local resources look like for you and your family, and how we can advocate for your family and educate families across the United States. Now, it's pretty rare, and you might be feeling like it's hard to find somebody who truly understands this stuff. And that's because we are rare. Out of the entire United States, there are over 263,000 financial advisors. But out of that 263,000, there are fewer than 200 financial advisors who focus on special needs planning the way that we do here at Consolidated Planning Group. So we understand that, that's fewer than a tenth of a percent of all of the financial advisors who specialize in this. So when you are with Consolidated Planning Group, you have found that little niche area and those experts who can truly help you. Some key concepts and things to think about before we jump into today's topic. We want you to start planning as soon as possible. Sometimes people say, oh, my child is too young. Well, not really, because the longer runway you give yourself in terms of time that you have to plan, the better it's going to be for your family. It'll be less stressful. You'll be able to put more thought and consideration into your decision making and not be just, doing it to get it done at the last minute. You're going to have time to think about exploring your options. Think about what's going to happen after high school. After your child graduates, there are educational options, there are vocational resources. And of course, there are plenty of transition programs and residential communities for your loved ones. So we want you to really think about, you don't want your loved one to graduate to the couch to play video games or just to watch movies all day, every day. There are things out there that they can be doing, and we want you to think about those ahead of time. And we want you to think about what the future is going to look like for your loved one. Don't automatically assume that a sibling is going to be the best route to be a successor caregiver. Little Sarah, right now, she loves mom and dad. She loves her brother, Jacob. She wants to be there. She wants to support her family and be helpful. So, of course, she's going to agree that when she's an adult, she'll take care of her brother. But when that time comes, you know that taking care of someone and being a caregiver is a big, big lift. And if Sarah gets there, she might realize that she's bitten off a little bit more than she can chew. And the reality is that being a caregiver is much more difficult and time consuming than she realized. So she might not be able or willing to take care of her brother when the time comes. She might feel he's a burden and that she is obligated to do it because she told you she would help. And think about it from little Jacob's perspective as well. Here, he and his sister Sarah have been running mates and partners in crime and best friends all of these years. And now all of a sudden, Sarah's going to step into this role of caregiver. It might feel a little bit to Jacob like she's trying to be mom or she's trying to be in charge. And you're not my mom. And that can create some tension from his perspective too. So just think about those implications and make sure that this is the right path for your family before you just assume that a sibling is going to be a great caregiver. All right. So with those warnings in place, I won't take any more time from Miss Rachel because she is fantastic. We want to hear from you, Rachel, about wills, trusts, and guardianship. And I totally forgot to mention some very important things. Before I turn it over to you, let everybody know that, yes, we do record these webinars. Later on today, you will receive an email that has a link to the recording. plus all of these slides that we're presenting today. We will send that to you later on today. The other thing I want you to know is that because we're in webinar mode, we can't see or hear you. So please put any questions or comments into the chat box, and we'll get to as many of those questions and comments as we possibly can. We also have some that were sent in beforehand, and we do have those. We will get to those or try to incorporate them into the talk. All right, now for serious, I'm done, Rachel. You can go ahead and take over.
Thank you so much. It's wonderful to be here today. Let's go ahead and just get right into it, get to the next slide. I will tell you guys, so we're looking at a broad overview of a lot of different topics today. I'm trying to get your feet wet of all the different potential topics. There is a lot of information that I couldn't fit in this presentation. So if you have other questions, there's other things, there are great webinars that are already recorded that are on different topics. So if you just want to, if you don't have time to get your question answered, just know that there's great topics out there. All right, with that being said, let's talk about estate planning. So I commonly get the question, what is estate planning? What does that actually mean? I'm told that I need to have my will. What else do I need? This is all very confusing. Estate planning is setting up who is going to control and protect your property after you pass away. It's setting up a plan for who's going to care for you if you can't care for yourself, or maybe if you're not able to for some particular reason. You get to make all these decisions on what happens, but you also get to make decisions on who you give property to, how do you want to give it to them, and when do you want to give it to them. It just all depends on what you want. And if you don't choose your plan, the state of Texas will choose it for you. So you like to have one that's for you. Now, if you have a special needs child in your family, this is even more important because you're not just thinking about you yourself, you're also thinking about that child and continuing on that care for them. So it's important to have these conversations. I know it can be scary, but it's important to know and have that plan set up in place. We also want to make sure that any potential government benefits that are out there, we're maximizing what your child is able to receive, both during their lifetime right now while you're alive, but also after you pass away. We also want to have a plan for who's going to be taking care of that child with disabilities. Next slide, please. All right, generally speaking, estate planning is not just one document like a will. It's a lot of different documents and potential things that can be put in there. The most common one is a will, which I recommend for every single adult to have that will set up where you want your property to go. The other one that you may have heard of a lot, and we'll be talking a little bit more about in just a couple minutes, is a special needs trust. This is a special trust for your
What?
individual with special needs that helps you in order
Uh-huh.
for you to be able to you decide where that property goes, protect that property for that individual, and really set up a plan for them. We also want to make sure that we're designated guardian for your child with disabilities, but also for you yourself in case you are incapacitated. A big thing that people forget about that's really important, especially if you have a special needs child, is your beneficiary designations. So think about your IRAs and your life insurance. Usually, whenever you set up those accounts, you set up where do you want that money to go after you pass away. Most people, when they're doing that, they say it goes to spouse and then it goes to their kids. If you have it going to a child with special needs outright, it could potentially disqualify them from government benefits. So I recommend you look at those designations because whatever's on there will supersede what's in your will. And a lot of people don't realize that. So we want to make sure we're having a consistent plan that's got all of these different things covered. Another thing that you want to do is coordinate with your other family members and tell them this information. We want to make sure that anything that they're planning on doing, say that they want to leave a gift to your child with special needs, it's not going to disqualify them from government benefits. And then we also want to make sure we have powers of attorney for you as parents on who can make decisions for you if you're not able to. Next slide, please. All right, so we're going to jump over to special needs trusts. Before I do that, I want to give you a little bit of a primer on government benefits because I think it's important for you to understand that and why it's so beneficial to have a special needs trust. Generally speaking, there's a couple of different programs that I'm going to talk about today. There's a lot of other programs out there. These are the most common that we see for young adults that are turning around 18. First, we have Supplemental Security Income, or SSI. This is $994 per month this year for food and shelter. There's also another program called Medicaid that's healthcare insurance for young adults with disabilities. There is another program that your child may be eligible for called Medicaid waiver programs. These give additional services beyond traditional
Nicole, oh
Medicaid,
my God.
and those programs give additional services like attendant care, respite care, therapy, residential, or even medical supplies. So those are great programs your child may be eligible for, and it's impacting everything that you need to consider in your analysis. With SSI and traditional Medicaid, not talking about the Medicaid waiver programs at this point, but you have to have a disability determination, low income, and limited resources. Now, anything with Medicaid waiver programs, they all have different requirements. The important thing that I want to mention to you is if you don't take any other action today, I would check one, if your child is on the Medicaid waiver wait list, and then two, where they are in that list so you know. What we've recently been told by Collin County here at LifePath Systems, which is our local Medicaid office, we've been told that there's generally about a 15 to 17-year wait list for these programs. Now, it depends on the program, they're all a little different, but if your child is not on the list for these, it's going to take a while for them to get to the top. So if they're not on those lists, please put them on the list so that they might be eligible here in the future. Next slide, please.
And since you brought that up, and people always have questions, I'm going to put the phone numbers for getting on the waiver waiting lists in the chat box. There's at least two phone numbers that everyone on here is going to need to call. One of them is your local authority, but I'm going to put that in the chat and not take more time to go over that verbally. Go ahead.
Wonderful. Thank you so much. All right. Now, I mentioned income and resources and that they have to be a lower amount. What does that actually look like? What is considered to be income or resources? So for income, for SSI, it needs to be less than $1,690 that they are working per month. Now that's for SSI. For Medicaid, it's generally speaking less than $2,000. Income is considered to be shelter, cash, and then any asset that can be converted to shelter. So it's not just the income that they have coming in from working, it's also income coming in from other sources. If they are under 18, your income as a parent is deemed to them. Essentially, you're all part of the same household, so they consider your income as part of this. Whenever they turn 18, then they're their own household, and it's the assets that are in their name that they're considering. If you are in Texas, if you're receiving $1 of SSI, you will have Medicaid eligibility. So these generally work hand in hand to make sure that you can also have Medicaid eligibility. Let's talk about resources next. Oh, excuse me. I got a little bit ahead of myself. All right. So for income, in-kind support and maintenance, or ISM, is also considered to be income. This is whenever someone else provides food or shelter for that individual. Now, I want to point out that this rule did change. It is now, as of September of 2024, it's only shelter that impacts them. However, you're going to see a lot of resources online that say that it is food and shelter. The rule did change. It is only shelter, but you're going to see that everywhere. So just be aware of that. If someone else is providing shelter for that individual, say that you are a parent, they're living in your home, you're providing a home for them. There is a 1/3 reduction in the amount of SSI that they received. There's a couple different strategies on how to not have this reduction. Really quickly, you could pay rent, pay your pro rata share of those expenses, or run through an ABLE account. And there's other information. We just don't have time to get into it today, but that's something to be aware of. If you're receiving a check that's about $600, that might be the reason why. Next slide, please. All right, so resources. You have to have less than $2,000 in countable resources. What is not counted is a home, a car, their personal items, and a 529 education account. Everything else counts against them for research purposes. This is bank accounts, uniform transfer to minor accounts after age 21, any investments or other real estate that is not the homestead property. All of those things would count against them for government benefits purposes. Next slide, please. All right, so we're going to switch gears slightly. Whenever a parent passes away or starts taking Social Security retirement, there is a program that they could be eligible for if the child was disabled prior to age 22. So some people call this disabled adult child, some people call this RSDI, but this program, essentially you get half of a parent's Social Security check for that child, and it's addition to whatever the parent's Social Security check is. After being on this program for 2 years, they are also eligible for Medicare, which gives additional resources. Generally, the network is bigger for individuals that take Medicare over than Medicaid. But you can be eligible for both Medicare and Medicaid at the same time. And I find that a lot of families want to be eligible for both. Next slide, please. All right.
Nope.
So special needs trusts, generally government benefits are insufficient. So we're talking about approximately $994 per month. That is not enough to care for your child with special needs. It's a great start. It gives them a lot of resources and things that you can protect the other assets that you have. However, it's not usually enough. So we want to make sure that you're keeping all of your potential options open. Anything that you want to leave to them as an inheritance, you can use that for other things that the government benefits don't provide. When I'm talking about this, we want to supplement whatever the government benefits provide. So we want to make sure that any inheritance, anything that's there for that individual, it's in addition to the government benefits. It's not replacing them. This strategy, what makes the special needs trust so special is that it's not a countable resource and it will not have a loss of the government benefits if you have that.
Okay.
So let's go into the next slide and I'll talk about that a little bit more. All right, so a special needs trust is not a countable resource. I talked about a home, car, personal items, all of those things don't count. A special needs trust that has the proper provisions, proper drafting from an attorney, and then is correctly distributed out by the trustee will not count against the individual as a resource. So it doesn't matter how much money you have in this account, it's still not going to count against them for government benefits purposes. And I mentioned supplemental government benefits. We're not using this. We're going to use the government benefits first, and then we're going to use the special needs trust. That's the whole purpose. I want to supplement whatever's going on. Apologies, I just spilled my water that was sitting next to me, but that's totally fine. Okay, then we want to make sure that it is making sure everything is there for them, everything that they might need. The distributions from the special needs trusts are also not considered to be income if they're done correctly. So a reminder, in order to be eligible, you can't have more income than the typical amount. You can't have more resources. So a special needs trust, it's not a resource, doesn't count against them for income. It's not going to impact their government benefits. Next slide, please. All right, now what is a trust? A lot of people hear this word and they're not sure what that is. Generally speaking, it's a legal document or it's within one of your legal documents like your will, and it's a blueprint for caring for your child. So we're setting up the people that are in charge of the money and the people that are caring for your child. It can be different individuals. We're setting up that money is going into that trust and it's going to create a safety net where the beneficiary is not in charge of that money. There's someone else managing and caring it for them. Now, a lot of people are in a situation where they're not sure if they need government benefits or not. It's a gray area for them. Maybe they do now, they don't in the future. Benefits are not the only reason for a special needs trust, although a lot of people use this as the primary reason for having a special needs trust. So it has flexibility for changed circumstances. If that individual is not on government benefits, it operates as a typical trust, which would be for their health, education, maintenance, and support. So it still can support them with anything that they need. The biggest difference between this special needs trust and a regular trust is that the trustee can never be the child with disabilities, and that's a requirement for a special needs trust. So this is also great because maybe they have the ability to be more independent. They don't need to be on government benefits, but they're not great at financial planning, managing records. Someone else is doing that for them, and there's someone that's really protecting them from bad actors that are trying to get into their money. So it can be really helpful even if you don't think you really need government benefits. Next slide, please. All right, there's two types of special needs trust. The one that you probably heard that people are saying, you really got to get a special needs trust, they're probably talking about a third party. Let's talk about the differences. A first party special needs trust is created with the individual with disabilities' own money. Typically, this is from inheritance where they inherit outright. So their parents didn't do any planning, but we need to fix it afterwards. That's the inheritance I'm talking about. It could be from child support or it could be their own savings from working, but it's that individual's own money. They have it, it's in their name. If it is in their name, it's in this first party trust, there is a Medicaid payback provision. What this means is this if they're ever on a Medicaid program, the state of Texas is going to keep a detailed record of how much money they spent for that individual during their lifetime. Then, after your child passes away and the trust administration's over because they passed away, Medicaid will be paid back first before it goes to any other beneficiaries. And that's because it's that individual's own money. It's not someone else's own money, right? On the next slide, we're talking about third party. Again, this is probably what you've heard of before. This is when it's someone else's own money and it never passed hands and goes to that individual with disabilities. So say you're setting up your estate plan, you really want to leave an inheritance to your child, it's going to be a third party special needs trust because it's your money, it's not your child with disabilities' own money. There is no Medicaid payback provision. So it goes to your child with disabilities. Say that you have a neurotypical child, it would then go to your neurotypical child after your special needs child passed away. Next slide, please. Okay, say we set up the trust, everything's good to go. The trust doesn't work unless we put money into it. So we have to make sure that everything that you have that's setting up all of your bank accounts, your will, everything is going to go to the special needs trust that you want to go for your child with disabilities. So your will needs to specifically say everything goes to the special needs trust, not to my individual outright. If it says it's going to that individual outright, it will be a situation where we would need a first party trust. So we want to make sure that everything's going to the third party. Most people fund these types of accounts with their life insurance and their retirement accounts. There's some great tax benefits that I don't have time to get into with retirement accounts, but that's something you should definitely talk to your financial advisor about. And then the gifts are also a great source for special needs trusts for funds. If your grandparents want to leave that money to them or siblings, it can also go into the third party trust. Child support, that's a big one. It needs to go into the first party trust. Next slide, please. Okay, child support. So really briefly, this may not apply to any of you or might apply to just one of you, but it's really important, so I want to cover it. After age 18, life support can be ordered, or life support, child support can be ordered for life for that individual with special needs. If it is after age 18, that child, it will count against them as income. So depending on the amount of child support, it will either reduce or completely lose their SSI and Medicaid. To avoid the loss of those government benefits, the divorce decree or a divorce modification document, if you already have one in place, must order that the child support is paid into a special needs trust, not directly to that parent that's covering for that child. It has to be a first party trust because that child is legally entitled to the child support. So if this is anything similar to your situation, I strongly recommend you talk to a special needs trust attorney and to a family law attorney. Okay. I hear a lot, well, do I really need a special needs trust? I have these other individuals in my life. I think it would work. Let's talk about the most common things that I see and why I don't recommend them. With no inheritance, if you decide I'm not leaving any money to your child with special needs, I think the government benefits are fine. Maybe that's right, but you're leaving them permanently with just the amount that they're receiving from government benefits and the healthcare benefits that they receive. If they need anything else, they don't have a fund to carry that child. So I strongly don't recommend that. If they inherit all of your funds outright, you don't have a will, or you just don't get this set up, if they inherit outright, it's going to go into a first party trust. And the issue with that is it's going to have the Medicaid payback provision. So just be aware that that is something that would occur. The other thing is that I often hear, well, I'm going to just leave it to his sister, that she's going to take care of him. She's going to do a great job. Maybe that's true. You don't know what's going to happen after you pass away, and you won't be there to see it. So that might be the best person in the world. We can't guarantee that everything's going to be perfect. Another situation that could come up is they don't plan their own estate planning to leave that money to that special needs child after they pass away, and instead it goes to their spouse, or it goes to their kids, or it goes somewhere else. If you have a special needs trust, we're guaranteeing those funds stay with your child with special needs, and then it can go to the other siblings. But just be aware that I hear these often, and they do come with a lot of issues. All right, let's switch
And what
gears.
about
Okay.
the situation where the sibling, maybe you leave everything to the other family member and then they get married, but then they get divorced.
Mhm.
And part of that money is wrapped up in the divorce now. So it can be a disaster.
Yeah. And the reason I mention those is because we've seen bad situations happen. And so we don't want that to happen to your family. All right, let's switch gears and talk about guardianship. I know a lot of you had questions about guardianship and how that works. So generally speaking, whenever you have a child under 18, you have a lot of duties and things that you need to do as a parent. You're managing money, you're managing doctor's visits, medical care, you are controlling their educational decisions, providing housing and food for them, managing their treatments and services like their therapy appointments and things like that. After age 18, any child, any individual, doesn't matter if they're neurotypical or a special needs child, they get the decisions to make their own decisions what they want to do, right? Now, the young adults in charge of finances, education, residence, they have the ability to sign contracts, get credit cards, leases, but they might be vulnerable to predators because they don't understand what that looks like. And so we have to have a mechanism that helps that individual if there might be these particular situations. Next slide, please.
Getting some comments in the chat box about some background noise. And so if you need to close a door or something like that, Rachel, I think you're the only one who could have any background noise right now because there's nobody in here and we're the only ones unmuted.
Yes, ma'am.
So,
I'm not hearing any noise on my end. So I'm not sure where it's coming from.
I don't hear anything exactly.
okay, I will check into that as you continue. Sorry about that,
Thank
everybody.
you. Okay. Then, for the guardianship, what if that young adult's unable to make decisions that are needed to care for themselves? So if they're unable to manage their finances or their medical care, they need maybe just assistance. What can we do for them? It could be that they're able to make their own decisions with assistance, or it could be that they just need someone to make decisions for them themselves. So what happens in that circumstance? Next slide, please. So for guardianship, there is a legal process that takes away the civil rights of that individual and replaces someone else, usually it's a parent, but they are the ones that make the decisions for that individual. So it is a court-created relationship between the guardian and the ward. The ward is the person that needs help, usually the person with disabilities, and then the person that gives help is the guardian. Most of the time, a guardian is a parent. It could be grandparents. It could be siblings. It could be any individual. Most of the time, it's parent. If you're hearing me say parent and child, that's just that's what I usually see. The court is the one that ultimately makes the decision if the proposed ward is unable to manage their personal or financial affairs. Now, if the court determines that the proposed ward is not able to manage their own affairs, they will appoint a guardian or co-guardian and then take away the rights of that individual. And essentially what happens is the guardian makes the decisions, not the ward. Next slide, please. So there is a growing legal trend away from guardianship, especially in Texas. The goal of this movement is to make sure that any adults retain as many civil rights as possible. This is a wonderful thing, and I'm all for it. But the effect on guardianship proceedings is if you do need a guardianship, it needs to be a little bit more stringent. We want to make sure that we're really doing all of our due diligence. And so it may take you a little bit more time to go through that process. An example of this change is just because your child is in special education, it doesn't necessarily mean that they need guardianship. Next slide, please. Okay, there is two types of guardianships. There is guardian of the person and guardian of the estate. A guardian of the person makes medical and living arrangement decisions for that individual with disabilities. A guardian of the estate handles property and finances of the person if they have assets. Generally speaking, the court is looking at if they have more than $2,000 in assets, but it could be a little bit different depending on your situation. With the guardian of the person, you have to do an annual report to the court. With the guardian of the estate, you have that as well, but there's an annual accounting that you need to do, and it's a little bit more involved. Remember that the court creates this relationship, and so the court's monitoring it every year to make sure you're doing everything that you need to. Next slide, thank you. All right, so there are partial guardianships and total guardianships. A total guardianship is whenever that person with disabilities retains no rights in the proceeding, and so they don't have any of their civil rights. They're not able to make that decision. Then a partial guardianship is where they're able to do some, but not all of the tasks that they're able to do. So they retain those particular rights. The most common are the right to vote, drive, marry, and determine their personal residence. Doesn't have to be all of these, it could be just one, but that would be called a partial guardianship. You may also hear of something called a temporary guardianship. This is when immediate action is needed because we have to protect the person with disabilities. It's for a very, very short window. Usually we're talking 14 days, but you have immediate action that needs to be taken care of. Next slide, please.
Before we go on to the next slide, I just want to quickly say to be very, very careful about allowing the right to marry. People don't understand sometimes and don't know that getting married will cause a loss in benefits. There are 2 or 3 places specifically where I'm thinking about benefits that could end if you get married. For example, if your child gets married, they will no longer be entitled to your Social Security later on in life. And that's a big deal because that could provide a lot of money for their care. So please watch our other webinars and pay attention to that particularly.
All right, now say that I'm talking about guardianship, that seems too extreme for your child. There are other options that are called less restrictive alternatives. The goal is to make sure that the child with disabilities is the most independent and self-reliant as possible. So for the guardian of the person, the most common are a medical power of attorney, where only if they're incapacitated, then someone can make a medical decision for them. They could have a durable power of attorney, meaning that they can make any banking transactions, do anything that they need to do, but then whoever the power of attorney agent is can also make those decisions, pay off bills, things like that for them. They could also have a supported decision making. I'll talk about that in just a second. Then you can also have a guardianship of the estate. So if you have alternatives to guardianship of the estate, most of these typically work for our young adults that are turning 18. Again, it just depends on your situation, but if you are the representative payee for the Social Security check, that is an alternative to guardianship. So if that's the only income that they're receiving, you can be the person that's in charge receiving that money and spending it for them. If you have a special needs trust, the trustee that is handling that inheritance or that money would also be an alternative to guardianship. And you could also have a joint checking account as well. We find that a lot of people don't need the guardianship of the estate, but again, please talk to your attorney. You may need the guardianship of the estate. Okay, supported decision making. For supported decision making, there is a supporter and a decider. The decider is the person with disabilities. They will choose their supporters, and the supporter helps them gather up information about whatever decision they're making. So, where they're going to live, their supports and services, where they want to work. Then they discuss the decision with the decider, and the decider makes the decision, and the supporter helps execute. So essentially, I want you to think about this like the supporter is determining the risks and benefits and helping communicate that in a way that the decider understands. It's a written form. It's a great option for a lot of people. It needs to be signed and notarized by both the person with disabilities and the supporter. Next slide, please. All right. Now, the advantages of the supported decision-making agreement are the child's rights are not withdrawn, they're not curtailed. The child is in control of all the decisions, and it's really about freedom and being able to make their own decisions. The disadvantages is that there's no court supervision. There is a potential for conflict and abuse. They can have a supported decision-making agreement for anyone. And you can't necessarily force someone to honor it. I will say that a lot of people don't know that this exists. It's been around for just over 10 years now. A lot of people don't know that it exists, and so you might encounter some issues out in real life. It also might not be enough care and protection for your child, depending on what their abilities are. Next slide, please. All right. For the guardian of the person, what their duties are is making sure all of the ward's needs are met. You're thinking about daily decisions that they have to make. You're making those decisions for them. So where they live, who is their medical provider, what medications are they on, where they work, their education decisions, and who has access to that individual. Guardianship of the estate handles all their money, investments, property. They can sign contracts for them. They can sell property with court approval. And they really just manage the financial side of their care. Next slide, please. Now, there's a lot of things that a guardian can do. There are some things that a guardian cannot do. So a guardian does not place a ward into a mental health facility. They cannot force medication on that individual. They do not take individual responsibility for any illegal actions for that proposed ward. And it doesn't really fully protect the ward from making bad decisions. They still make all their own decisions. With a guardianship, you're saying they don't have the legal ability to make a contract, for example. So you can get them out of that situation, but you can't prevent them from being in that situation in the first place. You also are not obligated to pay the ward's debts with your own assets. So that's something that I hear a lot of concerns about. Now, with guardian of the person, you need to renew every single year. There's an annual report, usually on the court's website. With guardian of the estate, you have to file a detailed inventory and investment plan, and you have to get permission to buy and sell assets. That annual accounting, you do need to hire an attorney each year to help fill that out.
Most people with disabilities are not really going to need a guardian of the estate, though, right? Because they don't really have typically that much of an estate.
That's
Is that
correct.
what you're finding?
Yes, and let me back up just a second. So we're mostly talking about young adults that have been disabled since birth, or they had some kind of tragic accident early in life. This process it's for those individuals, but it's also for older individuals that are losing capacity over time. So it's the
Mhm.
same court process. There's protections in place for both, and there might not be things that just don't apply to your situation, but it's because it's for that older population. Okay, now is guardianship appropriate in your particular situation? I want you to think, is the guardianship truly necessary to care for and protect that individual? You have to determine that the less restrictive alternatives don't work before we go into guardianship. And that's one of the questions that they will ask you as we're going through this process. Can the person make decisions that are in their best interest, or are they unable to make those decisions? And then can they provide their own food and shelter? Do they need that additional support? The biggest one, and I think this is a concern for a lot of families, is would that person be vulnerable to being taken advantage of if they had all of their civil rights? Next slide, please.
And you can be the same person can be the guardianship of the person and the estate, right?
That is correct. In fact, the same person can be guardian of the person, guardian of the estate, and the special needs trustee. There's no prevention for that. Some families like to separate it out, separate out the money, and then separate out who's caring for it. It's your decision. But a lot of times it's the same individual. Often a sibling is the one that's there, or a family friend. Okay, with guardianship, we want to look at, are there any alternatives that are going to meet the needs of that individual? And have you done everything else possible to make sure that that person has independence before filing for guardianship? And your attorney will help you with all of that. Next slide, please. All right, last slide, I believe. So I often get the question, when do I need to create a special needs trust? When do I need to worry about guardianship? A special needs trust is not related to guardianship at all. I do a lot of those for special needs trust clients that are also going through guardianship. That's a common situation. However, you can do a special needs trust as soon as you know that you need a special needs trust. You just want to do it before you become disabled yourself or before you pass away. We don't know when that's going to happen, unfortunately. We don't have a crystal ball that tells us when we need to plan for everything. If you are ready to have these conversations, you know how you want to structure your plan or have a general idea, it's worth having a conversation and talking about this and setting it up. If it's too difficult for you to think about that in the future, you can wait a little bit. And, it's one of those things where, yes, we're probably going to have to do it in the future, but just think about what the best situation would be for your family, and if you're ready to have those conversations. For guardianship, you can start the filing process as soon as 6 months before the 18th birthday. If they're already over 18, you can start at any time. The earliest that we can statutorily file in the state statutes is 6 months before the 18th birthday. I usually don't meet with clients until it's about 7 months before, so we can get ready for that 6-month deadline. The hearing itself cannot occur until 6 weeks before the 18th birthday, and then the order cannot be signed until that person's 18th birthday because they don't have the civil rights, so they need to have those rights before they can be taken away. So just be aware of that. Now, what is the result of wise planning, getting all these steps in place? Really, it's setting up your financial plan of how you're going to pay for your child's care after you pass away, setting up a support team of who is going to be the individuals for each person. One thing that's really important that you can think about is instructions for the care of that child, things that you know as a parent that no one else does. And what we do at our office is we give you something that you can write in and give you some guidelines on how to write that document. Then we want to make sure that they're retaining eligibility for government benefits. But ultimately, what all of this is about is making sure that there's a lot of well-being and then there's a lot of care for that individual after you pass away, but also peace of mind for yourself. That if you're going to pass away, if something's going to happen, there's a plan. And I can't tell you how many people in my office feel so much better because they actually have a plan. Even if it's not perfect, we have a plan. All right, thank you guys so much, and I'm happy to take any questions.
Perfect, perfect. We do have some questions in the chat box, Rachel. I just want to let everybody know that in the background, I might go ahead and switch the slides after I leave Rachel's slide up for a while. So write down her contact information, but yes, you will receive these slides later on. And we'll get through all of these questions. So One question that I saw that I did not hear you talk about at all yet is, well, someone says, what type of guardianship would you recommend? And that's highly personalized. You need to have a conversation with that family to help them determine what's best for them, right? But if you as a parent have guardianship, can you transfer that guardianship to, maybe the person who's going to take care of the trustee or anything like that? How does that transfer work when you can't do it anymore?
Great question. So, you remember in the beginning of the presentation, I talked about designating a guardian as part of your estate plan. There's two different ways to do this. So, one is in your will itself, you can say who you want the guardian to be. What we do in our office is we actually have a separate document. It's kind of like your powers of attorney, but it's called a designation of guardian for my child. It's the same document that you would do if your child's under 18. It also applies if your child's under guardianship. That decides who your preference is for being the guardian, and it passes on after you pass away. Now, the judge can say, I know this is your preference. We can't do it for this person because of this reason, that something came up in their background. But there's another person that you can say who I don't want to be the guardian. And the court's going to take that into consideration as well. So that's a big part. You can do that. Now, if you don't, what will happen is someone will need to apply. They will have to know all the immediate family members. So siblings, parents will have to all be notified. And then that whoever wants to be involved can be that guardian. So you can designate it, or it's probably going to be someone in that close family group.
Perfect. Now, there was one question in the chat box about if I have a joint account with my child, does my income outside of that account count as assets for SSI and Medicaid? And I can take that one. The answer is no. If your child is above age 18, they're not going to look at the parents' assets and income, only the child's. But just to clarify, because it's not perfectly clear in your question, do not commingle your money with your child's money. Make sure you're keeping that completely separate. Now, your name can be on their bank account so that you can help them and have access and whatnot, but you do not want to mix up your money. Do you want to say anything about that, Rachel?
I think you covered it. It was wonderful.
Okay. Can the person who is under guardianship sign documents like employer forms or um, their own driver's license?
So technically speaking, they don't have the legal authority to do that. Yes, they could sign documents. However, it could be pulled back because they don't have the ability to contract. In practical terms, sometimes they will still need to sign documents like a driver's license if they have the right to drive. It just means that it's a gray area. There's no particular law on it, but they might have to for some particular documents. It's something that, if you have the ability to, maybe they sign and you sign as the guardian, showing that there's authorization.
Perfect. So can you tell us a little bit more about the special needs trust and the, testamentary versus having a standalone trust? And, can you still designate the special needs trust as a beneficiary if it's not a standalone trust quite yet?
That's a great question. So a testamentary special needs trust is written inside your will. And that's all that it means is testamentary. So if you do that, that is an option for your estate plan. You can still designate on your life insurance, things like that, that it's going through your will. However, other people cannot designate it goes to your special needs trust. So say that it's going through your estate plan. We don't know whenever you're going to pass away versus whenever they're going to pass away. So they have to carry their own separate special needs trust. If we do a standalone document that's not written in your will, anyone can name that trust as a beneficiary. Most of my clients do the standalone because of that. There's also some tax benefits on leaving IRAs to a special needs trust that we can put those provisions in when it's a standalone trust. And so we recommend it for that reason as well. But if you want other people to donate, like grandparents, siblings, you would want to have a standalone trust.
And that's exactly what we recommend as well. Um, does are there protections in the guardianship for the guardian when that caregiver is dealing with somebody who is maybe rebellious or making those bad decisions and putting themselves in vulnerable situations?
Yes. So, well, one thing that immediately comes to mind is if you're in a bad situation and you don't want to be the guardian anymore, you don't have to be. So that's the first thing that comes to mind. As far as you're not responsible for their actions, and that's what I'm talking about. If it's a situation where they're in a bad circumstance and they do something illegal, you're not responsible for them and for their care. They are an independent person and their actions have consequences, but you're not legally responsible for that. And that's what I was talking about before. But if you're in a situation where it's dangerous for you, you don't have to be that guardian anymore.
Okay, and so you can cancel the guardianship. How does that work?
So it wouldn't be necessarily that you're canceling it because they'd still need a guardian, but you would resign as the guardian. And then, generally speaking, you would apply to the court. You would tell them, I don't want to serve as guardian anymore. If there's someone that can take over, you would have them take over at that point. If not, there's mechanisms with the court so they can find someone to serve as the guardian. There's other options out there. It's just not ideal.
Yeah, that would make the person a ward of the state, right?
It could potentially, yes.
Could.
Maybe not necessarily that, but it could be a situation where they have to hire a professional to manage their care. It's not the best situation if you can avoid it, but it is something that does need to happen in some circumstances, unfortunately.
Right. And that, that's like a last resort. This next question is talking about hiring a corporate trustee for the special needs trust as a
Mhm.
last resort. And yeah, I mean, if you don't have anybody, that's pretty much what you need to do. There are banks that do it, or, corporate trustees. There are firms that set up to do that. The Let's see. I applied for Social Security for my son. I'm still waiting on an answer. Will getting an attorney help? It was May 2025, and you're still, yeah, of course, your SSI is taking about a year right now to get a determination. So at 1 year, maybe start thinking about what needs to be done. Rachel, do you help people with SSI?
Unfortunately, I don't, but if you call our office and you're in North Texas area, I can refer you to someone that handles all of that.
Okay. Does the guardian have to live in the same town as the individual?
No, they do not. So the guardianship is based in the county that the proposed ward resides. So if they reside in Texas, I've had other ones where they were in a different county. That's totally fine. It's based on wherever that person lives. If they have their own independent housing situation, that's fine as well.
Okay. Um, oh, good. Okay, we're almost done with the questions. We got 2 more minutes, so hopefully we can get these questions wrapped up. I just want to let everybody know that at Consolidated Planning Group, we do offer a completely free initial consultation. So please sign up. It's on Zoom. It's usually like 30 to 45 minutes. We can give you some very helpful tips and advice, and answer any questions that you might have. So what is this person wants to know? First of all, we're going to send copies of the slides out, but what's the difference between a guardian and a healthcare provider's certificate of medical examination? Those are two totally different things, right?
So, a guardian would be the person that's going to be responsible. I believe the document you're referring to, maybe you meant a medical power of attorney, but the
Maybe.
healthcare provider of certificate of medical examination is the medical exam that's needed to start the guardianship procedure. So it says if that person, it gives a doctor's opinion on if they're incapacitated or not. You may have meant a medical power of attorney. In that circumstance, the medical power of attorney, that person makes all their own medical decisions, all of their own options. Then, if they are incapacitated, then the other person makes the medical decision. So it's different than the durable power of attorney. With the medical power of attorney, they define incapacity like they're in a surgery, they cannot speak, or there's something else going on, they have to be determined to be legally incapacitated, and that's a different definition. So it's a lot more extreme, and it's usually whenever they cannot verbalize what their decision would be.
Perfect. We are right at 1 o'clock. So I'm going to just tell, if we did not get to your question, please feel free to reach out to us. A couple things I see left over in the chat box. What things should I consider when selecting a guardian? We don't have anyone. Talk to the attorney. They will help you figure that out. Should the special needs trust be revocable or irrevocable? Typically, those become irrevocable when the person passes, correct? When the parent, so to
Yeah,
speak, passes.
it just depends on your particular situation, but usually revocable is what I recommend.
And again, if you're setting up a special needs trust, you need an attorney to help you do that. So ask that attorney that question. And then finally, and this one is kind of good, if my adult child collects expensive items, whatever they may be, does that count against him for assets?
It doesn't if they're personal items, but it really just depends on the type of asset. It could potentially, just depending on what it is, but it probably may not.
Like baseball cards or video games, retro video games,
I do not
things
believe
like that.
so. I don't believe so.
Now, if I see you, David, I know who you are. If I see you on that TV show, the auction TV show with that guy who auctions off Pokemon cards, and they do the program, the YouTube videos where they open the thing and you get that special Pokemon card. If you get one of those and you're going to be a millionaire, that could have a big impact. All right. I hope everybody has a fantastic day. Thank you so much, Rachel, for being here with us today and explaining all of these really, really important concepts to us. And to everybody who has taken the time to view this webinar, thank you. Please don't hesitate. If you have questions, Rachel and Consolidated Planning Group are here to help. It is truly in our hearts to provide you with the most help that we possibly can. So reach out and we'll talk about different ways that we can help you. All right. Have a great week, everybody. Thank you again for being here. You will receive these slides later on today. Bye.
Yeah.